So open that page, I'll search for my fix, find what I need in the deep dark abyss.
Welcome to the AI Skeptics podcast. Today we're going to have a really fantastic guest, Nancy Costello, who's going to talk to us about Section 230. She's an expert on Section 230 and also an expert on social media and its effects on young women. Jake has been doing a lot of work along these lines, so I'm just going to hand it over to him as a host today. Thank you, Jake.
Hello, AI Skeptics. Thank you, Kathy. And thank you, Nancy, for being here. It was really nice of you to join us and bring your expertise, especially on 230, which we've been thinking about a lot the last 2 weeks. Since the verdicts came out in New Mexico and LA around the social media and mental health and child sexual abuse material. So anyway, we've been thinking about that and excited to have you on. Do you want to introduce yourself?
Sure. Thank you for having me. My name is Nancy Costello, and I'm the director of the First Amendment Law Clinic at Michigan State University College of Law. And I'm also head up legal research for the Harvard-based Strategic Training Initiative for the Prevention of Eating Disorders, with this particular project focusing on the harms that social media is causing to children.
Thanks for being here, Nancy. Just nobody better that we could talk to about this topic. So we really appreciate it. We're going to divide today's conversation into 3 segments, as we often do. And we're going to talk about past, present, and future of Section 230. So for the first piece, the past, what's the origin of Section 230? What is that law? And what was its original intent? Maybe we could start there.
Sure. So Section 230 it's Section 230 of the Communication Decency Act. And this is an act that was put into place by Congress in 1996. So this is at the very, very early inception of the internet. I know the internet was invented back in the 70s, but in terms of wide public usage, it didn't see wide public usage till starting in the mid 90s and then thereafter. And that's when Congress put in place the CDA, the Communications Decency Act, and Section 230 is part of that. So we're now looking at a law that's 30 years old. And what Section 230 does is it provides immunity to internet service providers, including social media companies, in terms of what type of third-party content is posted on their sites. So if there's some type of illegal content, for instance, something could be defamatory, it could be falsehoods, it could be incitement speech. All of these things are not protected under the law. It basically what Section 230 says is that you can't sue the deep pockets of, say, Facebook or Meta or TikTok for a third party, an independent third party who puts up content that is illegal. It immunizes them from any kind of lawsuit. And it's a really strong shield for these internet service providers, particularly social media companies. And the reason it went into place 30 years ago was because Congress wanted to encourage the use of the internet and encourage communication on the internet. And if an internet service provider had to constantly monitor what was up on their platform for, is this illegal because it's defamatory? Is it illegal because it's child pornography? Is it illegal because it's incitement speech or something like that? We know there's so much content on the internet, it would almost be virtually impossible to monitor that. So it would, in effect, have it would chill speech on the internet if the internet service providers were responsible for any and all speech that gets put up on their platform. And that was the reason for it 30 years ago.
Yeah.
Okay, I just need to jump in and say that we absolutely must interview my mother on the origins of the internet, because she was one of the people that was working on that stuff back in the 70s, in the 60s, actually.
We're going to take an even deeper dive.
Yeah, deeper dive. Like, hey, this isn't deep enough,
Yes.
but this is pretty deep.
Because a lot of people don't know about that. When I tell my students this, who are all in their early 20s, I said, no, the internet existed back in the 70s, but it was really like the tech nerds who knew about it, right? The scientists.
Yeah, like my mom.
Right.
Yes, that's going to be a really fun conversation.
Fine mail super user.
And I also just want to mention that in the 80s, I was a bulletin board sysop. So I guess I was being protected at the time by that as well. Or was it me that was being protected, or was it the people who was it at that time when back
In the
then?
80s?
That's what I was wondering,
Yeah.
because like Meta and TikTok, they didn't exist in 96.
Yeah, and
when
there
this
wasn't really laws for the internet back in the 80s. It really, the laws really came into being in the 90s when you had a lot of public participation on the internet, and they were trying to inspire more, right? Because then that's when a lot of the businesses went, the bricks and mortar businesses went online. And that was when all these laws started going into place.
So was this like
I guess
AOL
what I'm really
was-
asking is, what is an ISP? What do you mean by ISP?
Internet service provider.
Yeah, I know what it stands for.
It
but
could be-
even so, like,
It's broad.
Yeah.
When we talk about it in the law, we use it pretty broadly. Meta is an ISP. AOL, ISP. Google, ISP. So it could be something massive. It could be something small.
So in the bulletin board in the 80s, would that be an ISP?
I think so. Yeah.
Okay.
Yeah.
Cool.
And again, this is how we've adapted it more in legal terms. What it started out as, what the definition was, I'm not quite sure in terms of how big you had to be an ISP.
It's funny though, like, does an ISP have to get money from its users? Like in the current definition, what is the notion of an ISP?
I don't know
I used to
that
think of
I'm
it- I remember
knowledgeable
from-
enough to tell you that.
From old days, it's like you had your ISP. That was who you paid a monthly fee. Like my family had AOL, so
Yeah.
we paid $20 a month for AOL, and that was our way to get online. Like
Right.
AOL provided us the service of access to the internet, but that's not how it works now.
No,
right?
and that was like the big platform, right? When you
Yeah.
refer to ISP, you could be referring to a website that hosts content where third parties are able to put the content up. So you can't sue the website host for the
Right.
third party content on the site.
Since we're coming to the end of this first segment, can you say a little bit about how Section 230 has been used by platforms like Facebook, Meta, TikTok in the past, 10 years or so to get around these kinds of liability issues?
Sure. So, if there is speech, or content up on these sites that is causing harm or, is seen as illegal speech, people have brought lawsuits because sometimes you can't even track down who put the content up, right? Or, just by looking at it, you can't tell who put it up sometimes. Of course, behind the scenes, you can track that down. And so people want to bring a suit against Meta to say, there's all this defamatory content up there and these falsehoods are hurting my reputation. And Meta, you're publishing it. It's kind of like when newspapers published falsehoods, you could sue a newspaper, right? And the newspaper was liable for falsehoods if it was published about a person. That's what's really different here. Meta's like this massive newspaper, if you will, and yet it's not liable for any of the content on there if it's posted by a third party and not themselves. And so,
But, so here's what's confusing about this. It is, sorry to interrupt you, Nancy. I thought you were done, but it's true that these big companies like Facebook are shielded by Section 230 and they're not responsible for lies. And we see that, or misinformation. But they definitely do try to take down, child pornography.
And they try to they have claimed that they audit their sites, and if they receive complaints and so forth, that they try to take it down. However, there's also been some studies done to show that they're not as prompt as they should be, or in cases they don't really manage to do this at all. One of the trials that we're going to be talking about, there was testimony in one situation where they had identified this person as bad actor number 2, and this bad actor was located in Nigeria. And he had been reported 900 times for doing something, posting bad content that was hurting people. It was reported 900 times before the account was closed. 900 times. And one of the users who reported the bad actor reported this 26 times, but the presentation stating that, hey, what's going on here? I'm reporting this again. They were all auto-closed with no action 26 times. So just how much are they monitoring this, and how effective are their procedures in taking down information or even checking it out?
One last question before we move on, and I know we do have to move on. Like, they do seem more excited to take down content where they think they're going to get sued for it, right?
Yes, of course.
Like copyright stuff?
Yes. YouTube especially with something like that, right? That they monitor for copyright infringement, and then they'll post a takedown notice, and they'll take it down.
Does Section 230 not protect them from if they host a copyrighted video? Like, is that a gap in the protection of? I
believe, forgive me here, I believe there is an exception here with copyright, particularly because so many of these sites like YouTube are showing music and so forth, right? And then musicians who haven't given their authority will contact YouTube. YouTube will check it out, and then they'll take it down.
Or likely the companies that own those recordings.
Distributors. Yeah. Whoever has the copyright on it. Yeah.
Right.
Yeah.
All right. So great. Thank you for the past.
Can I say one more thing with this, though?
Oh, yeah.
It's not just Section 230 that provides such a strong shield to the social media companies. It's also the First Amendment. So between the First Amendment and Section 230, they have massive protection, because the First Amendment protects the speech that they put up. That the social media companies post. They can either say, no, we're protected by, it's a free speech thing. We can put that up there.
What's the speech you're referring to where it's like the platform's own speech as opposed to some other user's post?
It could be a social media company. It also could be just the website operator, that they put up some really scathing opinion speech that everybody finds really offensive and objectionable. That's protected by the First Amendment, right? So the first party speech is protected by the First Amendment, and the third party speech is shielded by Section 230. So it's been very, very difficult to sue a social media company and get them to be liable for harmful content.
Well, okay. So, and I'm just doing a segue here, like algorithms that decide what to show you when, even though they're showing you third-party content they're protected from, those algorithms are kind of like speech, or are they?
So, Kathy, it used to be, I would say, maybe 20 years ago, in some of the very early cases, they looked at algorithms as possibly, yes, as speech. And some algorithms would still be speech. For instance, like a search engine algorithm. The search engine, you type in what you're looking for, and then the search engine algorithm produces in a ranking order what it's going to show you first, second, third, fourth. That would be considered speech by that particular platform. But are all algorithms speech, or should they be considered speech and therefore protected by the First Amendment? No. And we're just beginning to see some cases, these two big cases out of New Mexico and California, but there have been some other individual cases that have come down in the last 5 years that have suggested that no, not all algorithms should be looked at the same way. Some should not be protected by the First Amendment. And we've had a couple of Supreme Court decisions and some California Ninth Circuit decisions hinting at this, that we should be considering certain kinds of algorithms not as speech, but as product designs.
Right. Is that what happened in the New Mexico and California instance? They were considered products that were faulty, that caused some harm.
And before it went to trial in these cases, Meta, and I believe YouTube also, they were in the California suit, brought motions before the court to get the case dismissed. And they brought the case before the court to say, Section 230 prevents this case from going on. We're protected because this is third-party speech that was up here that the the plaintiffs are objecting to that they said was harmful. In the New Mexico case, it had to do with sexual exploitation of adolescents and younger than adolescents, prepubescent people, kids. And then in the California case, it had to do with looking at one particular plaintiff who claims that the algorithms used were addictive and they brought great harm to her. And in both of those cases, Meta and YouTube brought motions before the trial to say, dismiss the case. Section 230 protects us. And in both of those cases, the judges found, no, this isn't a Section 230 situation. This is about product design. And so therefore, it's we're looking at negligence claims and products liability claims, not speech claims. So it doesn't have to do with third-party content or First Amendment or First Amendment protection. They were specifically looking at product design of the social media platforms or the conduct of the social media platforms.
What did they have to do, the plaintiff side, to establish that these things are products, that these algorithms, the feed algorithm is a product, not a piece of speech?
Well, the first thing they did was the claims that they brought were negligence claims and products liability claims, claiming that this was...
It was just like, if I'm suing you for a product type thing, it must be a product.
Yeah. And so you have to claim that. And I'm careful, like even in my language now, right? I'm not calling, like recommendation, based algorithms. I'm not calling that content. I'm calling it a design. The algorithms might push content, but the algorithms themselves are not content or speech. The algorithms themselves are designed it's a business practice. And it's a business practice to increase the profits and the revenues that these companies are earning. And that's how they introduced the cases. And that's how they kept using that language, and they kept looking at the design. They didn't actually look at the content itself. They did. You had to consider the content. But the content can't
it's
exist.
Confusing. I mean,
pushing it.
Sorry to interrupt, but it's confusing to me because as a person who's thought a lot about algorithms, I think for sure they're designed. They're part of the design. They're part of the user experience. It matters how they're designed to the experience.
Mm-hmm.
But I also have been quoted saying, like, algorithms are opinions embedded in code. Like they also end up effectively being opinions. Like, this is more interesting than that. And they also respond to content, right? The content in two ways. First of all, they pick out certain types of content they editorialize in the sense that they push that content, but also the overall design of the system encourages certain types of content, which is why we've gotten so much more outrageous clickbait over the years. It's a feedback loop, right? It's a feedback loop of content and design. And I want these lawsuits to work. Don't get me wrong. But I guess if I were put up on the stand, I wouldn't be able to say that it has nothing to do with speech. Because it's definitely an opinion. Like they are asserting what's interesting and what's not interesting. I don't even know what a speech is, actually. Let me back down.
Yeah, because Kathy, when you're saying, I've had this thought before where I'm like, an invention, if I'm going to file a patent, like I have an idea for an invention, that's speech. Like I write it down on paper. Here's my idea. I want to build this machine. I want to get a patent for it. My blueprint could even be thought of as speech. But like, then you go out and build that machine and that machine hurts somebody. I'm not going to be protected by the First Amendment that I was like, well, I wrote down the blueprint here on this piece of paper and it was speech. So I can't be held liable for anything that happens, right? Like, sure, the lines of code, you might say somebody spoke those or they typed the lines of code that makes the feed algorithm, but like that thing's a product. It's a digital product and a machine.
I'm not disagreeing that it's a product and it's also design, but it's also a sort of constantly evolving opinion.
Well, a couple things. To what purpose is this? It's for profit, to increase revenue. Yeah. So it's a business practice.
Yes.
Right. And the other thing is so under the First Amendment, we don't have the right to speak. We also have the right to access speech. So when I type into a search engine, show me the best tennis shoes for running 10 miles, right? I'm seeking that speech. I have a First Amendment right to get that speech. But I might not be seeking the speech that comes after that says, oh, you want to lose 10 pounds in a month? You said this? Well, then here's not just the best tennis shoes, but this is what you should eat. And you should, as you keep, then it starts feeding you information to say you can eat less and less calories. You can eat as little as 300 calories a day, and you can run 10 miles a day, and you're going to lose those 10 pounds, and it's going to be perfectly fine. I never wanted that speech. I never was seeking that speech. All I wanted to know was about the tennis shoes to run 10 miles because I wanted to lose weight. And so therefore, it's not my choice of trying to access the speech. It's the social media company pushing that speech at me. So is that third party content, or is that a first party choice? It's their choice. So, and if it's their choice and they're pushing it, they don't get shielded by Section 230. And
okay, Nancy, I totally get that, but they do get shielded by the First Amendment. That's why I'm fixated on that, because it's like, it seems like you're saying that this stuff is these design choices, and we haven't even gotten to the addictive design choices like notifications every 15 seconds or whatever. But just in talking about the newsfeed algorithm, like I thought what you were saying is that it's a design choice and it's a product. Yes. And it is not speech. And I'm like, why isn't it speech? Like, I thought you were excluding the possibility that it would be protected by the First Amendment.
So these cases, these lawsuits are not trying to shut down the speech. They're not even trying to shut down bad speech. It can all exist. It's the way it's delivered that they're saying is harmful. The design in which it's delivered in is what's harmful.
Okay.
And that's really where it's at. Like, it's not about shutting down speech, but it is. So, and the social media companies fight this from both angles. On one side, they say, oh, it's somebody else's speech, Section 230, we're protected. And then the other side, they say, oh, it's our speech, so we have First Amendment protection.
Right.
Right. And we're saying,
so they're appealing these decisions, right? Are they
going to appealing the decisions out of New Mexico?
Do you think they have a chance of winning on that second argument?
In the Ninth Circuit, the California decision, I have high hopes that the Ninth Circuit will rule in favor of what the trial decision was, because the Ninth Circuit has some important decisions that have come down in the last 2 years where they have begun to differentiate algorithms. And they have specifically said that engagement-based algorithms might not be, it might be basically a product design and might not be considered speech. So there is some precedent law out there now that could be applied to these appeals. New Mexico is in a different circuit. They may use the Ninth Circuit. They also, there's a U.S. Supreme Court case called Moody versus Net Choice. And there is some, information in that case. It wasn't ruled on this, but there is some information in that case that also suggests maybe engagement-based algorithms are different than the other algorithms. Maybe that wouldn't be considered speech. And that was written by Justice Alito, Justice Barrett, Coney Barrett, and also Justice Kagan. So that's the law of the land. Now, it's not one solid case saying this. It is what we call dicta. It's information in the case, but that can be applied to cases. So I'm very hopeful, particularly in California with those Ninth Circuit cases. But I'm hopeful that the New Mexico case, as it goes up on appeal, could also look at the landmark decision of Net Choice versus Moody.
By the way, for our listeners who are worried about the time, we're in the third segment now. What's going to happen? Because this is what's going to happen, right? What's going to happen is arguments over the First Amendment. If we've got around 230, is this the next line of defense? And the question I have for you, Nancy, is it, like what you just discussed, is maybe the appeals will not find that the algorithms are speech. Is that the only way to win is that the only way for the judges to deny the appeal? Or is there a way to say the algorithms are speech, but that speech had harmful consequences, and so it's still not okay? You know what I mean?
Yeah. They could also look at the claims itself. Did they meet all the elements of that this was a negligent product design? Would there have been a safer way to design it? They can look at those elements of these causes of action, which is the product's liability action and negligence. I think the evidence that they presented was pretty damning. They had internal documents coming out of Meta that said that, in fact, they had valued teenagers, an individual teenager in the United States, starting at like age 14 or something, at worth $270 per teenager for the lifetime of their use on social media. Multiply that by millions upon millions of teenagers, right? And they also said that they were looking at children under the age of 9 because they were judging how they interacted with this technology. And they were going to try to leverage what they learned from that. And these are kids that aren't even supposed to be on social media platforms unless they have parental permission. This is pretty damning.
They're super creepy. The thing is that not only were they super creepy and harmful and negligent, but they're intentionally hurting kids. It seemed like they were intentionally blind to the harm in pursuit of the profits. I mean, just going back to the question of whether an algorithm is speech, it kind of reminds me of a conversation that we have almost every week on AI Skeptics, this podcast, which is like, do large language models think? Like, people in the vernacular, we talk about how these algorithms think and then they answer a question. But similarly, like, maybe it's just sloppy thinking to think that algorithms can be speech. To Jake's point, they were somebody's intentioned design at the moment of being written, but then they're on automatic. There's no intention with each new statement. Like, maybe speech actually requires intentionality or something of the moment. Like you make us, if it's coming out today, then some human being should have thought about it today.
Yeah.
Rather than it being on autopilot. Is that the kind of thing that the precedent in California is referring to, or is it different?
Well, when you talk about intent in the law, it does come into play depending on what the cause of action might be. Like, for instance, for defamation, especially if like you're suing a media company, the media company, the plaintiff has to prove that the person who published either had knowledge of the falsity of the information or they had a reckless disregard for the truth. So there is sort of at least a recklessness standard with that, It depends on what you're suing for when you bring in the idea of intent. But I did want to say...
It occurs to me, just to pause you for a second, Nancy, it occurs to me that an algorithm cannot have either a reckless disregard for the truth or like knowledge that something's false, because it doesn't think.
Right.
It doesn't have a model of truth at all. Right. So it would always fail for an algorithm. That litmus test would always fail for an algorithm.
Always fail. But the design of that algorithm pushing information is not the algorithm thinking per se. It's the design of how that mechanical electronic thing works.
Right. Of course, the person who wrote it was like, I'm just going to push this stuff because I'm going to have the algorithm push this stuff because then we're going to make more money. That was their thinking. There was thinking involved.
Yes,
but it happened a long time ago.
Sure. I wanted to go back to when Jake said, what's the future with this? I'm looking beyond these cases because this is social media platforms. The next big thing that's coming down the pike very rapidly are AI chatbots.
Yeah.
And that's the next thing my study group is pondering here. And is it going to be the same thing? A chatbot, is it speech?
Well,
is it speech or is it a design?
Somehow Nancy's frozen for me.
And these things are dangerous.
Nancy, I'm so sorry. I lost you for a second. Kath, was it my connection?
Yeah.
It was your connection, Jake. Yeah. But you could start again. Do you want to start again, Jake, with that?
I was going to ask Nancy to repeat herself because I didn't catch it.
Oh, okay. Well, I'll respond to Nancy, which is that, we've been working at Ocean on like chatbots and with Mitali Jain on some of the lawsuits against the chatbots. One of the things that's interesting about the chatbots and the harm for children, which is all over the place, not just for children, is that it isn't protected by Section 230, as far as I know, right? So they only have the First Amendment defense, if that. Like, what could you say a little bit about that?
Certainly, they might have a First Amendment defense for speech. I guess it would depend on where the chatbots are exactly, who's hosting them. I'm not positive about that, actually, Kathy. I haven't thought through it enough, but certainly the speech protection is what they're going to put out there as a defense.
Are you referring to that the chatbots generations will be considered speech?
Right. But actually, the first statement, I'm making two statements. The first statement I think is easier, is that it's not third party speech. It's their speech. They are generating this stuff. So Section 230
company, if it's like if
chatbots,
it's ChatGPT, then it's OpenAI is speaking.
Yeah, like Gemini or Character AI or ChatGPT. Like, they're generating speech. They're not.
Yeah.
I mean, they're actually stealing content from third parties.
They're training the AI, right? And then pushes out the output.
Yeah, they're stealing content to train the AI, then to spit it back at people. But they can't claim, oh, it's not our stuff, because they're the ones like munging it up and making it theirs.
I think that sounds true. I think that I have not thought all the way through that, but I think that's accurate. Yes.
Yeah.
Mm-hmm.
So the only thing they could possibly be defending, if they're like telling kids, don't tell your parents that you're killing yourself and go ahead and kill yourself, I'll help you, which is what they're doing, like, is that this is free speech.
Yeah. But so there was a recent case where a young man he did commit suicide, and the chatbot told him to do it and how to do it. But when he first said he wanted to commit suicide, the chatbot came back at him saying, suicide hotline's over here. I can't talk to you about this, etc. But then he got around it by saying, no, I'm writing a story, and I just need to know for my story, a fictional story, how this would happen. I want to get this information from you. And then the chatbot started talking and gave him all the information, and it resulted in his suicide. So the design of this, again, where's the safeguard there? If it's that easy to get around this, that's a problem.
You think that we're going to see cases that are trying to be product liability cases, the way the social media ones are, as well as cases that are going to say, here was some speech by a chatbot and it was harmful speech, or speech caused harm?
Yeah, I do think that we're going to be having that.
Be one or the other.
I know that there's already cases out there of people who have been terribly harmed in their interactions with chatbots. And what I understand from some other tech friends of mine is that they're getting, like, Reset Tech is getting a lot of questions about this right now, and they're starting to give presentations on it, and they're just trying to put it all together because it's so new.
Yeah.
I think that's the next thing we're looking at, though. Particularly when you're talking about harms to kids. Yeah.
Yeah, maybe we'll have another podcast soon to talk about the project we're working with on chatbot safety for kids. Maybe we can get Matali here. Like, we have the best conversations. We're really lucky. Like, doing the podcast is funny. And thank you for listening, everybody. Also, Jake, what's the email they want to send us comments to?
Oh, right. Any comments, questions, send them to aiskeptics@oceannetwork.net. That's ocean that ends with an N and network starts with an N. So oceannetwork.net. We would love to hear from you, AI Skeptics Nation. And Nancy, thank you so much for coming on today. I've learned a lot. I feel like we ended with more questions than I started with. So I'm going to take that as a sign of success. We're just at the beginning of a pretty exciting, hopefully, time in the courts on these issues. So maybe you can come back and keep us up to date on what's going on in some of these other areas too.
I'd love to. Thanks for having me today.
Thanks for coming,
Thanks,
Nancy.
everyone.
Also, maybe we could join the reading group that you have on chatbots. That'd be cool. Okay. Yeah. Thanks, everybody. See you next time.
We'll see you next time.